This is Voice Power Media, the voice of the realm.
Good day, everyone. I'm Oshomi Precious. It is on this note I welcome you to your number one legal talk show, Nigerians Know Your Right. This is a public enlightenment program that seeks to educate members of the general public their fundamental rights as citizens of the Federal Republic of Nigeria. It is brought to you by the students of the Law Faculty of University of Nigeria, Enugu campus, who are currently at home due to the ongoing strike that has kept us away from school at the moment. We've organized ourselves to interview some of the erudite personalities in the legal profession to bring to your awareness and enlighten you on your rights as a citizen of the Federal Republic of Nigeria. Today, we are at Barrister JNCC Obuka's Chambers, the Principal House of Laws, Obuka and Associates, Cicero Chambers, Enugu State of Nigeria. We shall be interviewing him today on the basic rights of female children as it relates to inheritance from their father's estate. Sir, you're welcome. I have two of my colleagues here. By my left is Joy Ugu, and by my right is Anastasia Ogwanya. Sir, you're welcome once again. So, the question we want to discuss today is the right of female children inheritance. Sir, can we really say that it is a reality today that female children are entitled to rights of inheritance of their father's estate?
Thank you for that question. Despite the provision of decisions of courts, despite the relentless efforts by Nigerian courts to actually settle this seemingly controversial issue through a legion of decisions, it does appear that there is a gap between the courts and the realities in different societies in Nigeria today. And that is why up to today, the issue continues to confront and bog our courts. But the truth must be said. The courts have discharged their oaths. The courts have come out to make it abundantly clear that a child that is born a female, notwithstanding that fact of her sex or gender, she cannot be subjected to any form of disability as a result or arising from the fact of her gender. This fact was given a constitutional consecration in the provisions of Section 42 of the Constitution, which, without any ambiguity, provides every citizen of Nigeria of a particular community, ethnic origin, place of origin, sex, religion, political opinion, cannot, by reason of the fact of any of this, be subjected to any form of disability, any form of stigmatization, deprivation, by reason of the fact that he is a citizen of such a community, place of origin, ethnic origin, sex, religion, or has such political opinion. That provision did not stop there. To make a very complete and comprehensive provision, in subsection 2, it provides no citizen of the Federal Republic of Nigeria shall be deprived or disentitled of any of his rights by reason of the circumstances of his birth. Even before this provision was a provision of the 1979 Constitution and later the 1999 Constitution. But even before then, and even putting it aside, you have in our law, customary law of every part of Igbo land. As a matter of fact, every rural community, every Nigerian community, before the coming of English law, what we call the received law, we had and practiced our respective customary laws. The Yorubas, the Hausas, the Igbos, Hadias, respectively. In the body of our jurisprudence, there is a test for the validity of every customary law. And that test has 5 conditions which every custom, every tradition, every customary practice must satisfy to be qualified as a valid custom. So even if you put aside the Constitution, which by virtue of section 1(1) and 1(3) is supreme to everything called law in Nigeria as the ground law, in the corpus juris of our customary law, there is a provision for a litmus test. The litmus test of validity of every customary law and practice is that such a custom must not be repugnant to natural justice, equity, and good conscience. Such a custom must not be inconsistent with any statutory provision. Such a custom cannot be in conflict with the provision of the Constitution. Such a custom must not be against any established public policy of the Federal Republic of Nigeria. Applying this test of validity to customs in every part of Nigeria, Igbo land in particular, you will see that the question is, these customs or customary practices which discriminates, which dehumanizes human beings because of their gender, which diminishes, which depreciates the value of the dignity of a person because of his sex, which disinherits women or female children, which stigmatizes them because of the circumstances of their birth. Is it not repugnant to natural justice, equity, and good conscience? And the Court of Appeal in Mojeku and Mojeku was confronted with that question. And without a recourse to the constitutional provision that I had earlier stated, the court held that custom in Igbo land, that custom which seeks to deprive, disinherit a female child of an entitlement by way of inheritance from the intestate estate of her parents is repugnant to natural justice, equity, and good conscience. By this particular pronouncement, any part of Igbo land, that was a custom, the only free custom in Anambra, precisely named. That custom and every such custom was rendered anachronistic, barbaric. In fact, the court said it was a Stone Age custom. It is atavistic to be found and to be associated with the 21st century, with the civilization of the 21st century. And to that extent, it calls profit down. But notwithstanding all this, because it does appear that there is a gap between the courts and the communities, because the courts are now, there is a deluge of this kind of situations. Courts are now being called upon to pronounce and repronounce on these things. That was in 1997. 2010. In the case of Moto and Moto, the same Court of Appeal was heard unequivocally, declaring that this custom offends against the basic principles of natural justice and should and ought not to be allowed. And to that extent, these customs were regarded as not valid customary law. So it's not a question of being a custom. These customs, are they valid? Are they enforceable? Are they acceptable? Because in your Lego method in the university, among the tests, among the features, the ingredients, the characteristics of a customary law is that it is not rigid, it's not static, it's flexible. True or false? You were taught it's organic. It is a reflection of the communities, the accepted way of life of a people, and it changes. What it was pre-1979, what it was before the case of Mojeku and Mojeku, Moto and Moto, cannot be what it is. And by virtue of these pronouncements and decisions, those laws cannot be regarded as laws today. They are invalid. They have been rendered invalid and null and void and of no effect. But notwithstanding that, we still had in 2014 the case of Ukeje and Ukeje. Female daughters who were doing their work, all of a sudden, the male children shared properties. Not only did they share it, but they equally went to the probate registry to obtain, probate registry of Anambra State, to obtain letters of administration, to be in charge of the estate of their intestate father. And a very brave woman in that family led the rest to go to court and to ask whether they are daughters of the father, the owners of this man, of this property, of this estate. And of course the answer was yes. The next question is whether by virtue of the fact of their births in this family as daughters of the intestate owner of this particular estate, whether they're not entitled to a share in the estates. And if so, whether the letters of administration already issued to two sons of the family without their knowledge and consent is not invalid for having not been obtained with their consent. The court answered all these questions in the affirmative, and the court made an order that the letters of administration be revoked, and the court revoked it. Not only that, the court issued an order that the administration, that the two persons that earlier got that letters of administration should surrender the management of the estate to the Administrator General of Anambra State. They will be managing it on behalf of the family until both the male and female jointly present people that will represent them to obtain letters of administration. In that decision went to the Supreme Court. And Ogunbi JSC, as it then was, who was one of those that made very telling pronouncements in that case, said, how can we, at this age and time of our civilization, regard female children as mere appendages? It's even a debauchery against their dignity, their dignity of a human person, to disinherit and disentitle them to a property of their father because of the circumstances of their birth. And in arriving at this decision, the court anchored pivotally on section 42, 1 and 2 of the Constitution, the 1999 Constitution, further supported with section 1.1 and 1.3 of the Constitution. In fact, in section 18.3 of our Evidence Act, the litmus test of validity of customary law is also further enshrined. That every custom in Nigeria which fails to meet this test, which is repugnant to natural justice, equity and good conscience, is invalid and will not be accepted in our courts. And this Evidence Act is the premise upon which matters are litigated in our courts. And whether or not it applies to customary courts, the Constitution applies them. True or false? And the fundamental rights of citizens are an integral part of our Constitution. And whether or not section 18.3 applies, the condition for the validity of customary law is enshrined now in all the high court laws of every state in Nigeria, including the FCT. So you see, the right of female children to inherit is protected, is as protected, in fact, is more protected than the city of Jericho. The wall of Jericho could collapse with these men, the children of God, singing songs of praise to God 7 times round as directed by God. But it is impossible, it's inconceivable and unimaginable to see anything that can collapse the wall of Jericho, the wall that has been built around the rights of female children in Nigeria. In Ogbuli and Ogbuli 2015, the courts saw a female daughter applying to be joined at the court of appeal as an interested party. She heard that her male brother, her brothers were sharing the estate of their father. He applied to be joined, and they said, "Who are you? You are a female child. You cannot be joined." An issue was raised whether she, in the light of the provisions of section 42, 1 and 2, section 18.3, and the decisions of the courts in Mojeku and Mojeku, in Moto and Moto, in Ukeje and Ukeje, cannot be, does not have an interest that ought to be protected. The court answered in the affirmative and joined that. The same thing happened in the case of Okafor and Isito, the same 2005, 2015. In fact, here in Enugu State, in the case of Ubene and Ubene, a decision of the Court of Appeal in Enugu, it rose from the High Court here. It arose from the city, a community called Egede, here in Enugu State. It was very, very intriguing because this daughter said, "No, we are educated. We won't allow you to share our father's property. What's the value of our education?" And they went to court. And the Court of Appeal said they are entitled. In fact, the decision is very clear. It said this issue is settled on a mountain of judicial decisions, that the sea is too settled to be tampered with today, notwithstanding their situation, their circumstances of their birth, their sex or their gender. If they indicate their interest, they are entitled to a share. Not just a share, but an equal share. Because equality is equity. If they are entitled as of a right. It's not a privilege. Even if it's a privilege, that same section 42 says that a citizen of the Federal Republic of Nigeria, of a community, of an ethnic origin, place of origin, sex, religion, or political opinion cannot be accorded any privilege or advantage which other citizens of other communities, ethnic origin, place of origin, sex, religion, or will not be accorded to. So you can see, even if it's a privilege, they are entitled to it. That is Ubene and Ubene. You see it in Duru and Duru. You see it in a whole lot of Emode and Emode. 2015. In fact, Ubene and Ubene is recent. 2016. And if you go down, if you now say, what of other type of female children? Because I once did a lecture about adopted children. And the worst is when these adopted children are females. They face a lot of stigmas. Children born of the same mother go to court. You can then imagine what will happen to people that are adopted. A time will come in life when those sentiments, when the man and the woman that adopted them will be no more. And the question is, what of the rights of a child? Does a child who is a foster daughter, does she have a right of inheritance? Foster, somebody who is born by somebody else but is engrafted by way of an application for foster parenthood. These things are by applications under the Child's Rights Act. Unfortunately, many people don't know the procedure for having a foster child. They just go, or adopted children, they just go and buy children from places and go for Thanksgiving and say they have adopted children. It's dangerous. It's dangerous because for there to be a valid foster childhood or valid adopted childhood status, you must have a certificate of adoption. So when these children will be challenged, the people that have adopted them will be no more. There must be a court. There are courts in every state that are assigned specially to deal with this kind of situation. I remember that in the case of Bertrand and the Whites, a child that is a girl who is a foster daughter was stranded and told that you don't have a right of inheritance here. And the girl went to court, Nigerian court, 2013, and the Court of Appeal that such a person, notwithstanding the circumstances of how he became a member of this family, is still entitled to the protection provided by our Constitution, our Magna Carta, under section 42, 1 and 2 of the Constitution. And she cannot be deprived or disinherited or subjected to any disability because of the circumstances of her birth. And the court upheld her right to an equal share, a foster child, a foster daughter. In the case of Aduba and Aduba, 2018, a child that was adopted, a female adopted child, was in court to ask whether her status is protected under Section 42 of the 1999 Constitution. And the court held that yes, an adopted child, properly adopted, is entitled as of a right to a share in the estate of the man and the woman that adopted her, notwithstanding the fact that she was adopted. As Christians of the Gentile race, we are all adopted children of God. The Jews can clearly tell us that we are not the original branch. We are adopted by God. So if we say that an adopted child does not have a right, what happens to we all who are Gentile Christians? Are we banished away from the kingdom of God by reason of the circumstances of how we were born? Because we were not originally called the children of God, but we have been adopted. And so, adopted children, notwithstanding the circumstances of their birth, are equally entitled to a share in the estate of their father. You also have a father. There was a case two cases I did recently for female children and male children. Well, female child born out of wedlock. When a female child gives birth to a child in her father's home and she grows up, can she be stigmatized because of the circumstances of the birth? The courts in Mbodu and Mbodu 2018 answered and said, shall we subject this child to such barbaric alienation, deprivation, dehumanization because of what a randy father and a promiscuous mother did some years ago in her absence? The answer is no. She too comes under the infallible protection of Section 42, 1 and 2 of the 1999 Constitution. And any custom or practice which seeks to deprive them of such entitlements is not only repugnant to natural justice, equity, and good conscience, but inconsistent with the provisions of the Constitution, and to the extent of its inconsistency is null and void per Section 1.1 and 1.3 of our Constitution. I think so. What you asked me, is it a reality? Looking at all these innumerable pedigree of cases, I will tell you that it is a reality today that female children are entitled as of a right to inherit from the estate of their parents. So it is a reality, notwithstanding massive ignorance, and this ignorance is what this kind of program, I hope, will tend to actually abridge. I think I've answered your question.
Very well.
Yes.
Sir, if a female child is held to inherit from her father's estate, does she have a right to deal with it as she so pleases?
That is that's one of the incidents of ownership. That's one of the incidents of ownership. And that actually came up in the case of Oguli and Oguli, because this female child not only got it, but he wanted to make use of it. See, the incidents of ownership are obvious. It includes the right to sell, the right to alienate, let's use the word alienation, or pledge, will it out, outright gift, anything. So it includes every right, every power, every privilege that the male folk will have in the enjoyment of that particular property if they were to be males. If it is not so, then it runs inconsistent with the provisions of section 42(2), which says no citizen of the Federal Republic of Nigeria shall be deprived or disinherited or denied any access or the enjoyment of the property because of the circumstances of his birth. So if there is anything he cannot do, it's still against the provisions of our Constitution. And in the hierarchy of our laws, the Constitution is the ground norm, is our Magna Carta, is supreme to any other law. And any law that is inconsistent with it is void to the extent of its inconsistency. I'm sure you people have learned that in your constitutional law.
Yes, sir.
Yes.
Okay, thank you, sir.
Yes.
The final question here is whether she has the right to ask for a profit of a communal, that is a communal property of the family, extended family of the father, whether she has the right to ask for the profit of anything or to ask for accountability of any sale of the communal
if
land.
it had been sold.
Exactly.
Good. I have a case I'm doing currently. Like I said, the right of property, when you say property is a penumbra of many rights, is a college of many rights, is a cornucopia of many rights. It includes the rights not only to sell, pledge, gift, will, or anything. It includes the right to ask for an account. He is entitled as of a right to ask for account. This property is the property of our father. Before I came in, you have sold it. You sold it without my consent. You sold it without my knowledge. I am entitled to an account. That is if he wants account. Why is he asking for account when he can ask that if the sale be what? Declared void? Because he is a joint owner. So if he wants the money, he says, okay, give me my own share. Otherwise, somebody like me will not even advise him to go for the money. I will go against that property. I will ask the court to declare that transaction what? Void. She is a co-owner, and the proprietary rights and interests she has in that property cannot be alienated without her consent. Nemo that what no habit. So you cannot give what you don't have. And if you have it jointly, you must have that consent agreement before you can sell. So if indeed she wants an account, she's entitled to it. But all these things are things he has to go to court through a very good lawyer. A very good lawyer. Because he has to have a good lawyer. Knowledge is fundamental. Knowledge is at the root of the legal profession. It is knowledge that distinguishes a lawyer from the rest. Umar the SAN said there are three professions: law, theology, and medicine. Others are vocations. What makes us learned is because of knowledge. So it is not the hood that we wear that makes us lawyers, because the Romans say cucullus munatus non facit. The hood does not make the monk. So with a very good lawyer, he goes to court, file the processes, poco a poco, little by little. One day there will be judgment, and he takes it. Thank you.
Very well, sir. One final thing.
All right.
To bring before you sides. You've mentioned ignorance. and some of the reasons most women are not inclined to pursue this action.
Yes.
Okay, we also feel like fear of the order of society where you have stronger men.
Yes.
So we want you to give one final advice to women that their proprietary rights are being derogated. What is your advice to them? What should they do when they are faced with these situations like this?
Knowledge is a universal right. Knowledge is a universal right. And the right to knowledge is encapsulated in the 1999 Constitution. The right to freedom of what? Information. The right to freedom of what? Information. It includes the right not only to disseminate, to impart, to give out information, but also the right to do what? To receive. That is why it also covers the right to own, establish, and operate a school of your choice. So, what you guys are doing is also part of it. Is you are bridging the gap. If anybody is hearing or is privileged to hear, come across this, she will discover that this is her rights. Again, there is very serious anachronistic mentality, atavistic mentality. We need to change mentality. Mentality has to change, but this thing has to change by reason of knowledge. Because there is one Guardian report, August 2020, where one traditional ruler in Enugu State, I think his name is Igwe Osisi Todo, was reported to have said that all these decisions of course that are seeking to empower women to have equal share in the estate of their father should not be practiced. I mean, it's not expected of anybody to raise up his head in communities like in his own community, perhaps, to say so, because it is entrenched, it is part of their culture, it's part of their custom, it is age long, it is the way of life of their people. He merely announced a very serious and unpardonable ignorance of the law. That custom is talking about, it has been regulated by law and subjected to a test of validity for it to be valid. That thing is mentioning is not valid. So there is fear. Some societies like that, what the man is saying could be true. In that society, in his society, or in other societies like that, that apparition, that bogus, that apprehension that the male folk will say, who is this? How can you say this? Is there. But notwithstanding these things, the law is clear that such things are no more the custom of those communities. The custom is not what they say is their custom. The custom is what the courts say is their custom. It is not the law is not what is in your custom in our village. The law is what the court says it is, or what the court will say it is. Have you read jurisprudence? When you come to jurisprudence, you will meet one school of thought, the sociological school of thought, or the realistic school of thought of jurisprudence. And one of the leading jurists and scholar in that school of thought is Roscoe. He said the prophecies of what the court will do in fact, and not in more pretentious, is what we mean by law. What court say is what is the law. It's not what he said there. I wish I could have one instance there. Then we drag the man to court, and then you test whether it is what she says, what he said, or what the court says. But these things are just born out of ignorance. And I believe that with this kind of programs, you will be able to emancipate women folk from the shackles of ignorance, from the manacles of some of these barbaric stereotypes, and set them free to enjoy the freedom that they have been ordained with. Thank you.
That was very insightful and educating, sir. We really appreciate you for affording us this opportunity to educate the general public.
The pleasure is mine.
Thank you very much.
I have it as part of my work as an advocate. People hear my voice only in court, so anytime I see the opportunity of talking outside the court, I talk, but I don't go to the motor parks. Yes, thank you so much.
Thank you
very
sir.
much, sir.
The pleasure is mine.
So, the general populace. Like the philosopher William Bratton said, we all have a fundamental right to live far from fear. And we not only have the duty to share that right, but the duty to secure it. We believe that with this enlightenment and this awareness, you'll be able to go out and speak for your right, fight for your right, and stand for it. Thank you for watching us today. We believe you've learned so much from this very educating and insightful program. You are free to leave your comments on our social media pages, on our YouTube and Facebook pages. Leave your comments, like and follow. Tell us what you think, and also solutions to this ravaging problem. Thank you very much, and see you Monday, same station, same time.
This is Voice Power Media, the voice of the realm.